Is it for any particular purpose? Is it a hobby? Is it a research project? Anything like that?
I don't know yet at the minute.
Okay.
Just sort of flying around, see what happens.
Right. I understand an officer's just tried to have a word with you on the way into the car park.
She sort of shouted at me in a plain clothes personal car, so I didn't have a clue who she was.
Apparently you've told her to pee off.
Did I?
That's what she said to us. If that's the case, that's not acceptable, is it?
Well, that's why we wear independent witnesses that never lie.
Right. What do you mean by that? Right, okay. Well, yeah, I've got mine on as well, so...
Well, thanks for letting me know.
Can I take your details, just so we know what you're doing, and you're recorded on our systems, and we've got the fact what you're doing, and to make sure you're not up to no good?
No, I'd rather not, if that's okay.
Okay. Why is that?
Because I haven't done anything wrong.
Well, I just need to make sure that you're not, like, sort of in line with any terrorist groups or anything like that you could be using for hostile reconnaissance or anything of that nature.
Do you suspect I'm a terrorist officer?
Well, I don't know until I speak to you. Do I? Until I take your details and check you through.
Is that what you do with everybody?
If you're being verbally abusive to people, then you have technically committed a public order offence, for which I would require your details.
Okay.
They arrive already pushing a fixed narrative, claiming you verbally abused the sergeant and presenting it as if it's beyond question. News Now Yorkshire refuses to get dragged into an argument. Instead, he stays composed and immediately points to his body-worn camera, calmly reminding them that recordings exist to preserve the truth without distortion. That moment shifts the tone, highlighting how quickly assumptions can be challenged when evidence is present. The contrast becomes clear right away. On one side, there's only a verbal claim being repeated with confidence. On the other, there's recorded footage that can verify exactly what happened. This imbalance raises serious concerns about how quickly conclusions are being drawn, especially when one version of events is treated as fact before any proof is reviewed. It underscores the importance of accountability and the role of unbiased documentation in situations like this. Then the situation takes a more serious turn. When he declines to provide his personal details, the reasoning abruptly changes, suggesting a need to check for possible links to extremist groups. This shift feels disproportionate and raises questions about intent, rather than a justified concern. It comes across as a tactic to apply pressure, escalating the situation without clear grounds and adding a layer of tension that goes beyond the original claim.
That's why I'm asking you for them as well.
Right.
So could I have your name and date of birth and address, please?
What, you think I've committed a public order offence?
Yeah, because an officer's just told me that you've sworn at her in the street.
Well, I need to get her to make that statement then, because she's lying.
Well, she's just told me as she's driven in that you've sworn at her.
Did she?
Yeah.
Right, well, I'll be making a complaint about her then.
That's absolutely
And if you
fine.
take my details, I will have to sue West Yorkshire Police.
That's not a problem. You feel free to do so. The reason I've explained the reasons why I'm asking you for your details.
What happens if I don't give my details?
Then you're potentially committing an offence.
Well, I will.
It's a lot easier if you do, isn't it?
Yeah, I don't want to give my details.
Okay.
I will if you tell me that I'll be arrested if I don't.
Well, potentially you may be. Yeah, it may make your arrest necessary under Section 24 of the Police and Criminal Evidence Act, because your name and address can't be verified. Right. And I've got reasonable grounds to suspect that you've committed an offence.
What reasonable grounds is that?
But I've been told by a fellow officer that you've been verbally abusive in a public place, which would be a Section 4A public order.
I have it all recorded, officer.
That's fine.
Do you want me to show you the recording?
Not at the moment, but I want.
Because I could show you the recording.
I want you to.
And then you would know.
Details, and I've explained it to you. You've asked me to explain it to you, and I've laid it out plain and simple.
This is the point where the reasoning starts to fall apart. They insist a public order offense has taken place, not based on any clear action, but simply on the sergeant's word being treated as final. When News Now Yorkshire calmly asks what happens if he refuses to provide his details, the response loops back on itself. It suggests that refusing could become another offense, which might then be used to justify an arrest, creating a cycle that lacks solid grounding. The explanation doesn't clarify the law. It repeats the same claim in a different form. Instead of presenting concrete facts, it builds pressure through repetition and uncertainty. This kind of reasoning raises serious concerns, as it shifts from evidence-based enforcement to a situation where authority alone appears to drive the outcome, rather than clearly defined legal standards. Bringing up Section 24 of Police and Criminal Evidence Act 1984 only highlights the weakness in the argument. The power to arrest must be based on necessity and supported by credible evidence, not rank, assumption, or convenience. In this case, the justification rests entirely on a colleague's claim, even though video footage is available that could immediately confirm or dismiss it. The decision to ignore that footage is significant, as avoiding clear evidence suggests a deliberate choice, one that raises deeper questions about intent and fairness in the situation.
Because of that nature, that's why I require your details. And as I've explained to you, if you don't give me your name and address, and can't verify who you are, it may make your arrest necessary in order to ascertain those details.
Will you arrest me if I don't?
I'm not saying I definitely will, but I'm saying it may make your arrest necessary.
Am I being detained right now?
At the moment, because I need your details.
Yeah, I'm being detained.
Potentially, if you don't give me your details, you may be arrested. Is what I'm saying.
No, I just want to check if I'm being detained right now.
I understand why you can't just give me your details.
I'd rather not. That's the point.
But I'm asking you to.
If I have to by law, then I will.
You do have to by law, yeah.
Okay, and what section of law says I have to?
I'm telling you that because you committed an offence.
I haven't though.
I suspect that you have.
You suspect that I have?
I suspect that you have.
Okay.
I only need reasonable grounds to suspect. That's 2 to 3 out of 10 on the scale of 1 to 10.
Yeah.
I've got that reasonable suspicion.
Yeah. Can you let me know that lady's name or collar number?
She's a sergeant who was off duty at the time, coming into work for whatever reason. I don't know why.
Because
she's a police
she's
officer.
lied to you. Now you threatened me with arrest, which has now made me have to give my details. So I will have to make a call to my solicitor.
Yep, that's absolutely fine.
Yeah. Okay.
You go right ahead.
This is the moment where the situation tightens, built around a justification that doesn't hold up under scrutiny. They corner him with a claim that if he cannot be identified, then arrest becomes necessary purely to establish who he is. News Now Yorkshire challenges this logic, because that's not how lawful arrest powers are meant to function. It shifts the purpose of arrest from a legal safeguard into a tool used to force cooperation. What unfolds next makes the issue even clearer. The focus turns to obtaining his details at any cost, with arrest presented as the default option rather than a last resort. But refusal to cooperate on its own doesn't justify detention, especially when the underlying suspicion hasn't been properly tested or supported by evidence. At this stage, what is described as reasonable grounds begins to look more like a convenient workaround than a genuine legal basis. The pressure created by this approach has a predictable effect. Faced with the threat of being taken in under a week and circular explanation, he eventually provides his details to prevent the situation from escalating further. It's not a decision driven by clear legal obligation, but by the weight of the circumstances closing in around him. When compliance comes through pressure like this, it cannot be seen as freely given. It reflects a response to force, not a choice made without constraint.
I can't believe she lied to you, officer. I have got it all recorded though, just so you know.
If you want to make a complaint.
Yeah, I will be making a complaint straight away. Yeah, definitely.
I haven't got
Is that what she actually said to you? I told her to pee off.
As I drove out of the gate, she was driving in and she said, "Will I have a word with you?"
Yeah.
Because she'd spoken to you and you told her to. I'm not going to say the full word. Pee off. You understand what I mean by that?
I understand what you're saying, but she's lying to you. You know that, don't you?
Well, if she's lying to me, she's lying to me. If it's on your camera, then you've got grounds for a complaint.
Yeah, 100%. Yeah,
I'm not lying to you. I can only go about.
You know, last time this happened, I got £1,000 for it. You know.
Right.
Yeah. That was at Humberside though.
What was that? What was that in relation to though?
Because someone said I was committing antisocial behaviour, so the officer unlawfully used Section 50 of the Police Reform Act to gain my details, just like you've unlawfully used Section 5 to gain my details. Okay. And then they offered me £1,000 for my trouble.
I haven't used Section 5.
Oh, what did you use?
You've potentially committed an offence under Section 4A of the Public Order Act.
Oh, okay. Section 4A.
Yeah.
And that requires me to give my details.
It doesn't require you to give your details.
You just told me it did.
What I'm saying, no, you're twisting my word.
Potentially under Section 4A. Potentially something more. That single word ends up carrying the entire argument, because there's no solid evidence being presented to support it. News Now Yorkshire highlights this clearly, pointing out that speculation alone cannot replace actual legal grounds. Section 4A of the Public Order Act 1986 is not triggered by the idea that someone might have caused offense. It requires clear intent and a real impact, something that can be demonstrated, not guessed. Without those elements, the claim remains weak, relying more on assumption than on anything measurable or provable in the moment. What raises further concern is how the justification keeps shifting. One moment, one power is mentioned, then it changes to another, and then something else entirely. This isn't a process of narrowing down the correct legal basis. It looks more like uncertainty and scrambling to find something that fits. If a genuine offense had been clearly identified from the start, there would be no need for constant changes. And despite all these shifting claims, none of the powers being referenced suddenly create an automatic right to demand his personal details. The repeated changes and reliance on potentially only reinforce the lack of a firm legal footing, making the situation appear more about pressure than proper procedure.
What I'm saying to you is because I've got reasonable grounds to suspect that you've committed an offence.
Yeah.
If you don't give me your details, it may make your arrest necessary under section 24 of PACE. Because your name and address cannot be verified. And I suspect that you've committed an offence.
Well, that's a full explanation. Thank you for that.
That's what I said to you the first time.
Well, I didn't get that explanation, so maybe you didn't explain it properly, and maybe I didn't understand.
Well, you understand it now, though.
I do, 100%. Yeah, yes. I can't believe she lied to you, and she's a sergeant. She's going around lying to you guys. Do you want me to show you the video?
No.
Is it because you know that she's lying?
I don't know that she's lying.
I think you know. I think you know. I think you do know.
We're literally just going off what we've been told.
Yeah, what you've been told is a lie, though, is what I'm saying. I could show you the video now and show you that she's lying. What do you guys reckon? Your personal opinion?
My personal opinion doesn't matter. I don't work. My personal opinion has to stay at home when I come to work.
Well, use your detective skills then. What do you think?
This is what I'm doing.
Yeah.
Speaking to you.
Well, yeah, I could have showed you the video.
To find out your version of events.
No, what you're doing is getting my details unlawfully.
Okay. I'm not. I've already explained to you the reason why.
I could have showed you the video, and then you would have no reason to get my details.
If you're happy to show me the video, I'm happy to watch it. It's not a problem.
Well, there's no point now because you've already given my details.
This is the point where any sense of fairness begins to fade. He repeatedly offers the most direct and reliable way to clear things up. Simply review the footage. Yet the offer is dismissed. News Now Yorkshire draws attention to this, as one officer openly admits she is relying solely on what she has been told. That isn't an independent assessment, it's acceptance without verification. His account isn't compared against available evidence. It's set aside entirely. Instead of examining the footage that could confirm the facts in seconds, they lean on second-hand claims and treat them as sufficient. This choice creates a clear imbalance, where hearsay is given priority over direct proof, raising serious concerns about objectivity and procedure. What makes the situation more revealing is the timing. Only after his details have been taken does the video suddenly become important. That sequence speaks volumes. If the footage truly mattered, it would have been reviewed at the very beginning, not at the end. Leaving it until last doesn't reflect a genuine effort to establish the truth. It suggests a move to manage the outcome after key decisions have already been made.
So I might as well speak to my solicitor now and get my £1,000.
You've offered to show me the video, then that's fine.
Yeah. You see that your sergeant's a liar.
Well, show me it if you want to show me it. I'm not bothered.
Am I being detained?
No, you're free to go. Thank you for giving me your details. Just be careful where you're flying it.
No, I won't.
Obviously, bear in mind that side of the gate and the fence is private property.
Oh no, I've already been over there.
Right, okay.
Yeah, I'm going to go over again.
Right, okay.
Yeah.
But bear in mind that you may be spoken to again by an officer if it's deemed that your drone's interfering with any police activities or anything like that.
All right, well, I've got permission to be here.
From
the Civil Aviation Authority.
Okay, have you got that in writing? Have you got anything on you can show me to confirm that?
Do I need to?
Well, I'm not just going to believe you, am I?
Well, I'm not just going to believe you that your sergeant's a liar.
Okay. Well, I'm not going to get drawn into this back and forth with you.
You've already been drawn into it.
I've spoken to you. I've ascertained what you're doing. As long as you're not interfering
what happened
with
to the
police
Section
activities,
4A?
That's fine. I'm not going to take any further action against it.
No further action?
Yeah.
Why? Because you know that she's a liar?
I'm going to give you words of advice.
No, I don't want your words of advice.
Well, I'm going to offer
you can stick your words of advice.
Right, I'm going to offer you them anyway.
No, I don't want them.
The moment they obtain his details, the entire situation comes to an abrupt halt. No offense is followed up, no further action is taken, and the urgency that once filled the exchange disappears completely. News Now Yorkshire highlights how everything previously mentioned, public order concerns, references to terrorism, and various legal sections, simply fades away without explanation. That kind of sudden shift is difficult to ignore. If those earlier claims had real weight, they wouldn't be dropped so quickly. Genuine concerns don't vanish the second basic information is collected. The speed at which the situation is abandoned suggests that those points were never being seriously pursued in the first place. Instead, they appear to have served a temporary purpose rather than reflecting an actual intention to act. Looking at the sequence as a whole, it becomes clear that the focus was never on resolving an incident. The primary objective was to establish his identity, and once that was achieved, the interaction had effectively run its course. The legal language used throughout didn't lead to any meaningful outcome. It functioned more as a tool to reach that single goal.
If I speak to people in future,
but I didn't speak to anybody in any. She's a liar. I never told her to pee off. She's an absolute liar. I will be making a complaint. Okay. I will be suing. Thank you very much. What's your details?
6468.
From the station?
Yep.
Your details?
290.
From the station?
Yep.
And her details?
She'll find those out for you. I believe her name's Sergeant Wiltshire, or Wiltshire, my apologies.
Sergeant Wiltshire?
Yep.
And her numbers?
I don't know them.
Well, I need her numbers.
I don't know them.
We'll have to radio through then.
I don't know them.
She's the one that made the complaint. I need to make a complaint about the lying sergeant.
Just ask to speak to Sergeant Wiltshire. She works on Team 4 Patrol South at Ellen Road. That's all you'll need.
Well, can't you just radio through and ask for her details?
No, because she's not actually on duty at the moment, because she was in, as you said, she was in a civilian car in a civilian clothing, so she's...
You could ring the control room and ask what her call number is.
I can't do that at the moment because I'm too busy, but you've got all the details.
But you weren't too busy to come and stop to talk to me?
Thank you very much.
Yeah? See you later, sausages.
I prefer bacon.
He makes it clear this is heading to court, because the entire encounter rests on claims that don't match reality. A sergeant alleges he used abusive language when he didn't, and that version is repeated by others without anyone stopping to verify it against the available footage. News Now Yorkshire shows how quickly the situation escalates, with threats of arrest used to pressure him into handing over his details. Then, the moment they get what they came for, every other concern quietly disappears. That shift is telling. This isn't a simple misunderstanding. It points to authority being used in a way that raises serious questions. When a narrative is accepted without evidence and action is taken on that basis, it leaves little room for fairness. At that stage, a courtroom becomes the only place where those claims can be properly tested and examined against actual proof. The issue of accountability becomes even clearer when he asks for their caller numbers. Instead of a straightforward response, he's met with dismissal. Suddenly, they claim to be too busy to provide a basic detail that allows follow-up or scrutiny. Yet just moments earlier, time didn't seem to be a problem when they were stopping him, questioning him, and pushing for his personal information. That contrast highlights a one-sided approach, quick and assertive when they want answers, but unavailable when asked to provide them. What stands out most is the pattern. Evidence that could resolve the situation is ignored, while identification that could support a complaint is treated as optional. The interaction builds rapidly, leaning on pressure and repeated claims until compliance is achieved. Then it ends just as quickly. No charges, no action, no continued interest. That outcome speaks volumes that if this had truly been about public order, national security, or any genuine concern, it wouldn't have been dropped the second their objective was met. The way it unfolds suggests the process wasn't about resolving an issue, but about reaching a specific outcome. If you found this breakdown insightful, consider liking, sharing, and subscribing to help keep these discussions visible. I'm the Audit Assessor. This was episode 11. See you next time.